I call this meeting to order of the West Hollywood Rent Stabilization Commission. Will you please join me for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Commissioners, can you please ensure your microphones are on and all the cell phones in the room are set to off or silent? Ms. Barino, may we have a roll call?
Yes. Commissioner Kirpies?
Present.
Commissioner Bergstein?
Here.
Commissioner O'Keefe? Here. Commissioner Maggio? Commissioner Topchian? Vice Chair Gregor?
Here.
Chair Charity?
Here. Thank you. Moving on from item 3 to item 4, approval of the agenda. Commissioners, having reviewed our tonight's agenda, do you have any changes to it or a motion to amend, or approve?
Motion to approve. Second.
Thank you. All those in favor, can I hear aye?
Aye.
All opposed? Thank you. The motion passes. All are in favor. Moving on from item 4 to item 5, approval of the minutes. Commissioners, having reviewed the minutes of our last meeting, do you have any changes or a motion to approve?
Move to approve as submitted.
Yes, I would Commissioner Gregoire's mother passed away yesterday,
Yes.
and I would like to honor her by adjourning this meeting in honor of Chrisanne Gregoire.
Thank you so much. We'll have that for the notes that we'll be adjourning the meeting in the memory of our fellow commissioner's mother, Chrisanne Gregoire. We do have one motion on the table. Is there a second?
Second.
Thank you very much. All those in favor?
Aye.
All opposed? Thank you. That motion carries. Moving on from item 5, approval of the minutes, to item 6, public comment. Do we have any public comment this evening? No? Moving on from item 6 to item 7, our director's manager report from Mr. Noonan.
Good evening. Looking at the calendar and the upcoming meetings, we do have appeals scheduled at your October 25th meeting and at your November 8th meeting. Of course, there is no second meeting in November, and the commission has canceled the second meeting in December. So the final meeting of the year, December 13th, it has no appeals as of yet, but that is still a calendared meeting. That concludes my report.
Thank you. Commissioners, do you have any questions or comments for our manager? No? Thanks very much. Moving on from item 7 to item 8, commission comments. Commissioners, this is your time to make some comments.
I would just like to announce that the Los Angeles Conservancy has designated the Berry House, and the reason why I mention it because it's 100 feet out of the West Hollywood, our boundary on the east side.
Excuse me, Commissioner Maggio, we've just been asked if the commissioners who are not speaking, if you can turn your mics off. So leave them off until you're actually speaking because they're getting a lot of feedback. Thank you.
Okay. The home was a 1939 streamlined style house, and the architect was William Kesling. It's at 947 Martell Avenue, which is just 100 feet south of West Hollywood. I would like for all of you to drive by one day. It's really very special, beautifully intact, and we were so lucky to save it, even though it's 100 feet out of West Hollywood. Individuals in that area of Los Angeles were very proactive to make sure that this wonderful stream house home was preserved. And that's my report. Thank you.
Any further comments? Yes, Commissioner O'Keefe.
So I was unable to participate in the seismic retrofit pass-through conversation because at the time I was advised to conflict myself out. But since then, the staff has been able to do more of analysis, and it turns out that more than 25% of the population of our city is similarly situated. So the conflict wouldn't apply. So if it's okay, I had a couple of quick comments that I wanted to make on the issue, although it's of course already been considered by the commission. Commissioner Kirby's and I co-authored an op-ed to WehoVille that we submitted that'll probably run tomorrow or sometime over the weekend. The item is going to the council on Monday, so no one will be conflicted out because of this new exception. And while the process was great, I really appreciate all the community hearings. It was so helpful to hear from landlords and tenants, and they really had my thinking evolve a lot based on what I heard from them. That all said, although the process was great, I would prefer a different solution. I think that it would be better if there was no pass-through in the cases where landlords are making a good deal of profit already, so that they would have to have, some kind of showing that they had a need to pass through the money. And also, I think it's very important, and our op-ed explains why we think it's important that the city take a significant responsibility as well, and that it cover hardship waivers, which should not only apply to low-income older residents, as the current staff proposal recommends, but any not only low-income resident, but also rent burden, because we don't want to see people losing their housing because they cannot afford this pass-through, which really is very important to preserving rent-stabilized housing as a whole. So I just wanted to speak briefly on it since I hadn't been able to at any of the prior meetings, and we have the op-ed that should run soon that'll explain our thinking further.
May I ask the commissioner why you are exempt? You said why you were exempt?
Sure. So the rule applies if you have a financial conflict. You are not conflicted out if the same conflict applies to the public generally. And that is defined as anything that 25% of the public or more is similarly situated. So in this case, more than 25% of the residential units in the city of West Hollywood are on that same list that Josh and my residents are on. So because it applies to so many people, that exception applies, and we aren't actually conflicted out after all.
And you just found this out?
Today.
Do we know if that list is final? That the buildings that are on the list, is it the final list? So do we know if it's a 25 or more, or could be less?
It is, I don't think they know for sure still, but at the time that we were asked if we would be conflicted out, they said at that time, out of abundance of caution, they didn't think they had enough certainty. But I guess now, I wasn't privy to all the conversations, but it was 28%, so there's a lot of wiggle room there. So I guess they just feel comfortable enough that they know that the exception applies. So any council members that would otherwise be conflicted out aren't either now.
Good. I could just,
Thank you all for all your good work on it too.
if I could just add to that, I just distributed to the commissioners, and I have a few extra copies for the audience and staff if you would like to. But we just wanted to at least give you guys an opportunity to see it before it was printed tomorrow, or we think it might be printed tomorrow. And I want to reiterate everything that Commissioner O'Keefe said about kind of the different approaches that we had discussed and considered, and likewise agree and thank all of you for everything that you did during the process. Thank you.
Thank you for that comment. I actually am in agreement with you, Commissioner O'Keefe. I do think along those lines completely, and I would advocate us all and the citizens of West Hollywood to talk to the council members and advocate for your position on this issue. I believe this meeting is coming up next Monday, so it is very timely for all of us to, as citizens of West Hollywood and not just commissioners, to talk to your council members and see and have your views heard. So thank you for this article. It's very good. And on a personal note, thank you, Commissioner Gregoire, for showing me what devotion to this commission is. It really is nice to see you tonight, despite your loss. And you have been a mentor to me as a fellow attorney and a commissioner and a friend. So you've really shown me a lot tonight. So thanks. It's good to see you. Thank you. We're just going to hold for a minute to get Commissioner Maggio a better hearing device. Commissioner Maggio, I just want to check in with you. Let me know when you're good to go.
I'm tuned in, thank you.
Okay, great. We'll move on from item 8 to item 9, our appeal this evening. This is Appeal D-4338 at the address 1326 North Flores, Unit 2-4. This appeal was filed by Ben Smith. Ben Smith, are you present? Thank you very much. The tenant who would oppose this appeal is Jonathan Hamill. Jonathan, are you present? No, thank you. At this time, we'll hear a staff report from our counsel, Ms. Regan.
Thank you. Jonathan Hamill has lived in Unit 24 at 1326 North Flores in West Hollywood since February 2015 at an initial rent of $1,795 per month. From the beginning of the tenancy, the landlord has been charging a separate monthly fee of $10 for trash removal. The hearing examiner found that this fee is an illegal rent overcharge since trash removal is considered a part of the rent under the rent stabilization ordinance. Because this conclusion is legally correct, staff recommends that it be upheld. Thank you.
Thank you, Ms. Regan. Commissioners, do you have any comments or questions before we move forward? No? Okay. So at this time, we'll hear oral argument from Ben Smith, or will there be another person making oral argument? Sure. Just so you know, the rules of engagement here, you'll have 5 minutes to make your oral argument. Please do speak directly into the microphone so we can hear you. And also just know this is an appeal, so you won't be able to present new information to us, only the information that was present for the hearing examiner. Should you present new information, we are unable to consider it. When you're ready to speak, please state your name and city of residence and begin.
Good evening. Wow, it's bright. My name is Brian Poirier. First name Brian, B-R-I-A-N. Last name Poirier, P as in Paul, O-I-R-R-I-E-R, resident of Los Angeles. Sorry, excuse me. First time I've actually had to come for an appeal. I think what led to this is kind of a strange situation. Normally when we do run into these kind of hearings, it's something about maintenance or reduction in possible service. This came about from determining the maximum rent. No idea of really what was going on until we showed up. We thought maybe something new with the increase. We brought the 3 years of increases and found that everything was okay with that. And then it came about that the issue was then with the trash fee. I think there's some jumps to conclusion that are being made in this decision. There's various places within the lease that the tenant signed and agreed and knew that he was agreeing to paying the trash fee. Back then when we started this, I believe it was 2015, it was kind of an old version of RUBS, Ratio Utility Billing System. I'm sure some of you might be familiar with the terminology. It's where you split up the cost of water, trash, sewer among the tenants. The technology back then wasn't as easy or cheap, so we just did divided by the number of units, and we came out to $10 per unit. In the evidence submitted, 5.1, 5.2 paragraph I, 5.3 paragraph 3, and 5.20, 4 times throughout the lease, the tenant acknowledged and signed that he was going to pay $10 a month, addition to rent, separate from rent. Evidence page 5.20 spells it out even further. In looking through the analysis by the staff, again, I think we're making some leaps to conclusion to say that it has to be included as a housing service. When you look at the rent re-registration form for a new tenant when they move in, there's various things that they can call housing services: electricity, gas. The word trash is not on that document. When it comes to the West Hollywood City RSO code and rent regulations, the word trash does not appear. In the entire chapter 17 of the RSO code and the entire rent regulation, I believe it's about 50-some pages, the word trash does not appear once. So to say that according to law, trash has to be required, I think is a leap to conclusion. There is a document from the City of West Hollywood called Tenants 101. It's a slideshow. Again, I won't present it, I'll tell you about it. There's a slideshow for new tenants moving to West Hollywood or signing new leases, Page 7 of that slide says lease provisions legal in West Hollywood. The second one listed is RUBS, Ratio Utility Billing Systems, for water and/or trash. That's the only place I could find the word trash. So in a way, the city is contradicting themselves in this message. The decision dated August 8th from the original hearing officer, page 4, Judy states that under the RSO code, again, it's not allowed to charge trash. There is no code cited with that statement. Page 6, conclusion number 10, it's stated again, it's illegal to charge trash, and there's no code cited with that conclusion. I think it's very prudent, and I mean, feel free to ask me questions, but I think this decision needs to be reversed because I think, you know, it's very concerning that we're leading almost down a dangerous road to say RUBS is not allowed. Because I can assure you, all of our competitors, now that the technology is there, are doing this on new leases. They're charging for water and trash. Thank you for your time. I don't know if you have any questions for myself.
Just a couple of questions. Mr. Parade, is it? Mr.
Poirier.
Poirier. Right. You just mentioned number 10. Where were you referring?
So the decision from the original hearing officer.
Uh-huh.
So I referenced page 4 and page 6, conclusion number 10, which is the only conclusion out of all the other conclusions that we found the rent increases were all legal. Nothing was done incorrectly. But the one conclusion, number 10, says that it's illegal to charge trash.
The one that starts, that says the landlord has demanded and accepted and retained illegal rent in the amount of $420 based on the monthly trash fee of $10. Is that what you're
I
referring
think
to?
you're further ahead, sorry. Page 6.
Uh-huh.
So number 10, yeah, landlord has demanded, accepted, retained illegal rent in the amount of $420. So again, we already, determined under the fact that the $10 per month was not rent, it was trash.
Commissioners, this is page 51, just so you know, in our packet.
Yeah, it wasn't cited as like evidence, it was the...
Yeah, no, you answered it. I just wanted to make sure I was looking at the right
Okay.
one. This isn't relevant to what's in front of us tonight, but I am curious, how many units are in your building?
This building, 30 units.
And is this something you've done
For
every unit?
For every unit that we've leased. Obviously, we have inherited tenants that have been there longer, they don't pay the trash fee because their lease wasn't written that way.
Okay, thank you.
You're welcome.
I don't think you read further enough. 17.08.010, number 10I, specifically second paragraph. Housing services also include the provisions to tenants of elevators service, laundry facilities, and privileges, common recreational facilities, janitorial services, a residential manager, and refuse removal.
Is that a question?
Oh. Thank you. No, nothing.
I had a question. So you stated during your comments that the tenant had signed off on this trash surcharge a number of places during their initial tenancy. And while this is not particularly germane to our decision tonight, I wanted to my fellow commissioners, page 37 in our record. It's a document that you also required your tenant to sign, says notice of intent to convert apartment building into condominiums, stating that if it so happens, the tenant will receive 120 days written notice of termination. The tenant agrees that based upon this disclosure and in conjunction therewith, tenant will not be entitled to receive and hereby expressly waives any claim to relocation fees. Again, while that is not germane to tonight's decision, that is also illegal under our ordinance. You cannot request, you cannot require, and a tenant is actually precluded from waiving any relocation fees. I haven't heard of a building converted to condominiums number of years, but for you to require a tenant to sign this document illegally waiving their ability to receive relocation fees, it's another example in the record of documents that you have required your tenants to sign that do not purport to our rent stabilization ordinance.
Commissioners, any further question or comment before we move on to deliberation? No. Oh, sure. Yeah, sure. Thank you, Mr. Poirier. We're concluded. This part's concluded.
Okay, I was just going to say if I could make one last comment. Or...
I think you've responded to
Okay.
Our questions. Is this in response to a question?
No. Well, I know Commissioner Maggio had mentioned somewhere in the code it mentioned to refuse.
Refuge.
I understand that's another word for trash service. But again, I think this could potentially be a bigger issue for other investors in West Hollywood and the citywide, because again, now that the technology is there and more accessible and cheaper, most of our competitors are doing this for all new leases. They're charging back for RUPS, which includes water and trash. So I think, and again, because in the Tenants 101 slideshow that the city put out for tenants said that that's a legal provision. Again, and we're not really, I'll leave it at that. But.
Thank you, Mr. Poirier.
Thank you.
We do have a question from Commissioner Kerpes to staff.
Yeah, I just had a question about, so the $10, I understand it's for rent, and, I'm sorry, not for rent, it's for
Which is 17.
trash. I think this microphone's still on.
No, you're looking at
For trash, and I understand that trash in itself is an illegal overcharge, or to charge for trash is illegal. What prevents the tenant from just not paying that $10?
Well, I mean, that's kind of outside the scope of what you're deciding tonight, but I can't tell you the answer to that. I mean, it doesn't sound, I don't know if that would be a grounds for eviction or not.
You don't know in our city? I mean, okay. So the other question I have then, so the addendum is part of the lease, is that correct? I mean, these 7 or 8 pages, even though some of it's illegal, I guess, the tenant, is that still considered part of a lease? I think we talked about this a little bit earlier, but can you confirm, or am I misunderstanding?
I mean, it purports to be part of the lease. I mean, I can't tell you for certainty.
I guess,
the
yeah, my
legal
question would be
landscape.
can an addendum, there can be addendums that make up a lease, or that can be added to the lease that make the lease.
It's not unusual to have a contract with an addendum if both parties sign it. I can't speak to that yet.
Yeah, thank you.
So we are in deliberation, Commissioners. Would anybody else like to start?
Excuse me. The ordinance is very clear, and I don't know how you could be evicted with an ordinance this clear, but it does talk about what I mentioned earlier, beyond furnishings, parking, private street cleaning, but very specifically refusal, removal, so.
And Commissioners, just so you know, this is in your blue rent stabilization ordinance packet on page 17-5. At the very bottom of 17-5, subsection I, you'll see definition of housing services on 17-I.
Chair, can I have a question. So, I mean, there's no doubt in my mind that this is a housing service, and I think that section referenced by Commissioner Maggio that describes what housing service is. It defines the housing service.
Yeah, I think where I see the connection is it says after, sort of connected with, the language I saw was connected with occupancy of the rental unit. So I thought that was I was reading it to be housing services connected with the occupancy, if that makes sense. No?
For some reason, I see it a bit differently, and I wanted maybe Ms. Reagan can better explain to me. If the reason why the examiner didn't, why the examiner concluded this $10 is an illegal overcharge is because it's not stipulated clearly on the rental agreement if the tenant should pay $10 at the beginning. Is that's the reason why it's the...
Are you asking how the hearing examiner reached the conclusion?
Yeah,
that
I
this
just
was an
want
illegal
to,
charge?
I'd like to understand the way the examiner was taking this matter, but why, if there was an agreement at the time and the tenant pay on first day of the tenancy that $10 extra fee.
So regardless of what the tenant agreed to, the rent stabilization ordinance takes precedence over that. And so if you look at, and I'm sorry, I don't know the page in your packet, but it's page 4 of the hearing examiner's decision, the second paragraph. She concludes, trash collection is a housing service related to the use and occupancy of the rental unit, and therefore it's included as part of the rent.
I have trouble
I think
understanding that.
ordinance also 17.44.040, specifically C, of substantial grounds for rent adjustment applied by the tenants. And the C of that will help, I think, also clarify that a little bit more.
So,
Commissioner, which
but-
section, which, I'm sorry, I didn't quite hear which section you were quoting, Commissioner.
17.44.040.
17.4.
That chapter, I don't think
The-
it
the
applies
tenant-
here because it's
the-
rent adjustments. so
Ms.
we're not-
Regan, I want to continue my question, but the owner never paid for the trash service from the beginning, right? The tenant was, that was the tenant's responsibility to pay for the trash services from day one. If I sign a rental, this is a hypothetical maybe, but I want to clarify. If I rent a unit and I sign a rental agreement, the rental agreement specifically says $1,000 includes everything, but there is an extra $50 fee for something else. Would that extra $50 be for a service that is outside of the rent that I'm paying? Or for trash, it would be a different standard, different way, I wouldn't say standard.
So you can't enter into a contract that's illegal, and so what the hearing examiner has concluded is that the provision that purports to have the tenant pay for trash is an illegal provision in the contract based on our RSO.
Okay.
And, okay.
So based on the RSO, because the RSO describes what the housing service is, and that also includes trash?
Correct, and there's a specific provision, 17.32.070, which says that you cannot waive any limits on the rent increase.
Right, on the oral and written agreement in country and public policy will be void. That's the one, right? Okay, thank you. I want to hear from other commissioners at this point. Thank you.
Ms. Reagan, I have a question as well. This is just for kind of the broader context. Are there any contracts like this that would be legal that a landlord could enter into with a tenant alongside a lease with additional charges? Would it be possible, or is that across the board? It has to be part of the rent and it has to be subject to all of these provisions?
So it depends on what they're purporting to separate out, and I tried to tie it to the regulations. It's similar to adding or removing a housing service. If it's something that can be easily separable, like a parking space, so it's not unusual to charge separately for a parking space. But for something like trash and water and sewage, that's an inseparable part of the rent.
Thank you.
So I guess that part I wanted to hear is that there could be a service outside of the rental agreement that the tenant can pay extra to have that service, just like parking or anything else.
Correct.
So it's not going to be an illegal charge. That's what I was kind of nervous about.
I see. It depends on what they're charging separately for.
But the utility has a different approach when we would deal with a utility or a service as trash removal service. Thank you.
There was an amendment adding this, and then the two parties would have to agree in writing, and that would be the only way you could charge. Isn't that correct?
It depends on the housing service. Again, if we're talking about parking, yes.
I'm talking
Trash,
about water,
no.
trash, if they said,
No.
no, they cannot at all.
No, that's what they
Even if that was a separate agreement, that could not.
That's what they purported to do here.
Right. All right. Thank you very much.
So I'm satisfied that I agree with the hearing examiner's recommendation and staff's recommendation. It looks pretty clear that even though the landlord may have acted in good faith, not knowing the law itself is controlling. It looks like we're told, and I believe, that it's an inseparable part of the rent to provide trash. In this case, the contract to have a separate payment for trash wasn't lawful, therefore it'd have to be repaid. That's my thinking.
I have another question for staff before I make my comments, sorry. So there are illegal overcharges of rent, which would be when the MAR is exceeded, or you've accepted more rent than what the MAR is. How do we determine from case to case whether the overcharge, I mean, I think in the hearing it was very clear that there was no tying the trash with the annual adjustment, which we are commonly see as where our MAR question comes in. So there was an intentional separation of the two. And if we accept the fact that that is an illegal contract, I mean, that is an illegal contract, how is it that we, why is it that the remedy for that is a rent increase hearing versus that's an illegal, unenforceable contract on a separate route? And I think, I don't know what makes one connected and what doesn't, but I think we've seen in other circumstances where there's been some sort of illegal act where we treat it separately than the MAR.
So I think I know what you're asking, and the fact that this is an illegal provision is not the end in of itself what you're concluding. That's just, that's based on the RSO. That leads you to the conclusion that this $10 charge is in fact an overcharge, a charge above the MAR. So the MAR is what the hearing examiner determined it to be, which is what's in the contract, what's in the lease, multiplied by the allowed AGAs. This $10 represents over and above what is allowed to be charged. So that's why the remedy, she's not necessarily providing some sort of remedy due to this illegal provision. That's part of the route to get to the fact that this $10 is an illegal overcharge, which needs to be refunded. Does that answer your question?
I think so, and as you were speaking, I think I was more clearly remembering in the past, and I think that there was a circumstance where we said, well, and I think it had to do with the 3-year rule about how far we can go back, that the MAR and accepting the MAR, or accepting, implying rent increases was illegal because they were not in compliance. Going above the MAR, or going above the AG, the allowable was also refundable, but it didn't have that statute of, well, the 3-year rule, but we still treated it the same way. Okay, that helps me. Thank you.
I actually think this case is pretty simple. Page 13 of our packet shows a re-registration form, and it indicates the initial rent rate was $1,795, and that comports with the finding of the hearing examiner that was the initial rent. Therefore, that extra $10 charge was in fact an illegal overcharge. Therefore, I would support staff's recommendation that we affirm the hearing examiner.
I'm also in agreement with many of the commissioners' comments. Just while we're on the subject, however, for our landlords in the city, what is their resource to check out their rental agreements and make sure they're in line with the laws of West Hollywood? Do they have just to put it on the record for anybody watching, or can they contact the manager of housing services? Can they?
Manager Noonan is telling me that there's a model lease available on the city's website.
We also provide a number of guidelines, and we do have training, educational workshops. We're right in the middle of our fall workshops now. We've done 2 tenant workshops. I believe we're doing a landlord workshop at the end of October.
Thank you. Yes, I do know these tenant workshops. Commissioner Bergstein?
Just a question to staff that if indeed we do vote on upholding hearing examiner's decision, does the city take to notifying the other residents of an affected building, saying that if you have been charged this separate illegal trash fee, that it is not allowable under the RSO, or is that not a step the city would normally take?
No, that is not a step the city would normally take. We would take it in certain circumstances, however.
I'm just going to.
Yes. Sorry, such as.
Pregnant pause.
It's like nobody yes.
I'm happy to chime in. I mean, from a legal services standpoint, if this is a widespread practice, the city needs to do something about that, and we will look into this. Until tonight, I was unaware that this was such a widespread practice because it's illegal under our ordinance.
Thank you.
Chair, thank you. So maybe regulations could clarify that. Maybe we can, amend the regulations to state something that the trash cannot be separated from the rent. And although, as I agree with Vice Chair Gregoire, it is a simple kind of a case, but I appreciate the clarification provided by the legal counsel regarding what can constitute what can be considered as an illegal charge as a trash fee. To be honest with you, I thought that if it's not stipulated in the agreement, the tenant could have paid for the trash separately, but it seems that now it's clear to me for the future cases. But with that clarification from the legal counsel, I will support the staff's recommendation to uphold the examiner's decision. Thank you.
So, Commissioners, have you all had a chance to read Resolution RSC 18-534?
I haven't gotten a chance to finish it, unfortunately.
Okay, do you want to take some time?
Yes, please.
Can I make another comment? Just so I'm going to. I don't find this case easy. Yes, I find it black and white to the statute, or to the ordinance, and I will support the resolution because that is the law, but I think it is something that, I don't think it's fair. I am somebody who in my unit, I pay X amount for rent and I pay one, if I wanted the parking spot, when he offered it to me, I could have paid $100 for the parking spot. I would have signed a lease, and at the end of every month, I'd be paying my rent plus $100. In this case, the landlord made a mistake by not just charging $10 more for the rent. The tenant's going to pay it either way. There's no surprises here. If it were any other service, let's say to use the shed out back all you want for $10 extra a month, and they took that away, we would say, you don't have to pay $10 anymore. So I don't understand why we can't just say, stop paying the $10 if you don't like it, because there's nothing they can do about it, because it's an illegal contract. I think that the landlord should learn. This city has never allowed to do anything specific like what this lease says you could do, the $10 for charging for refuse or trash. So that's really on you, but I do think you're getting an unfair outcome out of this. But I will support it because it is consistent with the law. I don't feel good about it.
I wanted to make an additional comment, just, and I'll address it also to staff later on in the evening, but you made a mention that with the change in technology, that it's widespread practice to charge for water. That is not true, to the best of my knowledge, in any rent-stabilized jurisdictions, unless you sub-meter your property and can prove that your tenant, by meter reading, uses much water. Those new services, which I've seen the ads in the Apartment Owners Association magazine, definitely not in West Hollywood, and I don't believe is allowed in any rent-stabilized jurisdiction. So I would caution much further research before you or any landlord attempts to start charging a tenant for water or for trash, for anything that cannot be subdivided out.
Yeah, I would have to agree. You know, we have a few lawyers up here, and I think it's common practice to get a real estate attorney to review your agreements to make sure they're in a alliance with the laws of the jurisdiction that you're in. That's quite common practice for a real estate attorney to do, and I would advise all the landlords in West Hollywood and other municipalities to please do so. Commissioner O'Keefe, have you had a chance to finish reading the resolution?
Did, thank you.
Yeah,
I
no
guess
problem.
I would, if there's, you're the one who
No, I'm
asked, if
happy
there's
just to
further
make sure.
discussion.
Yeah, I'm just happy to. I just want to make sure we all had a chance to read through it, because at this point, I think we're ready to put a motion on the table if anybody's ready to make one.
Sure, I'll make a motion.
Thank you.
Unless Commissioner O'Keefe would like to. I'll move the draft resolution. I'd like to make a motion to adopt Resolution RSC 18-534, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision on application D-4338 involving 1326 North Flores.
Thank you very much. The motion is on the table. Secretary Barrino, may we have a roll call for this vote?
Commissioner Kerpes.
Aye.
Commissioner Bergstein.
Aye.
Commissioner O'Keefe.
Aye.
Commissioner Maggio.
Aye.
Commissioner Topchian.
Aye.
Vice Chair Gregor.
Aye.
Chair Charity.
Aye. Thank you. The motion passes. For the parties involved, please do see staff if you have any further questions. Thank you very much. We'll be moving on from item 9, the appeal, to item 10, unfinished business. I don't believe there is any unfinished business, but I'll just check with the room. No? So if we're moving on from item 10 to item 11, an update from our ad hoc subcommittee.
So we had our first or second, depending if you count a pre-meeting meeting where we discuss questions to ask of staff. Today, we'll probably have at least 1 or 2 additional meetings. We had a number of questions about the process for the re-registration form and some specifics, and staff were very helpful with answering all of our questions, and we'll probably get into more of the specifics once we've had our last meeting. Commissioner Kerpes, do you have anything you want to add?
Nope, just thank staff for all their work on this, because I didn't expect you'd have all the answers that we had requested. I was nervous about sending it over, but they had all the answers to get us started.
Commissioners, any questions or comments for our subcommittee? None at this time? Okay. Thank you very much for looking into this. I'll be interested to speak with you about it. We're moving on from item 11 to item 12, public comment. Do we have any public comment this evening? No?
Fill out a form.
Oh, yes, you'd have to.
If you just grab a form in the back.
We'll wait for you. Yeah. Staff, I believe public comment is 3 minutes, correct? Yes, okay. So you have 3 minutes. They'll start timing you when you begin talking. And again, please speak into the microphone and say your name and city of residence. Thank you.
My name is Brian Poirier, City of Los Angeles. I'm very concerned with the committee's outcome tonight. Again, if you would take a look at Tenants 101, a slideshow that the city creates for tenants, slide 7, following lease provisions are legal. requiring renter's insurance, ratio utility billing system for water and trash. Just because a housing service is required does not mean a tenant and landlord cannot enter into an agreement before the tenancy begins to do anything otherwise as far as charging, as long as the service is provided. And then just my last comment is from here, or I don't know if I want to ask a question. As far as
Just be public comment.
okay, so I mean, I think again that this really needs to be reconsidered. RUBS is happening in LA, in Beverly Hills, in West Hollywood, in Santa Monica, rent control or not. The purpose behind it, and again, it's twofold, is it actually creates tenants to be more conscious of their use of, water and trash. Los Angeles just overhauled and franchised their trash system. The prices sometimes doubled, tripled, quadrupled on some buildings based on the fees that they required. And the only way to cut that fee is to get tenants to recycle more. The fact that we're able to pass on a lot of that cost to the tenants and re-educate them is actually leading to more recycling. So RUBS has a purpose not just to get more money out of tenants, it actually helps conserve as far as trash recycling and reducing water use, which is a big problem in the state. Thank you.
I wouldn't like to, I know we can't answer him, but I think I could add something that in my new building, there is a charge for water, but it's in the initial agreement and it's there for you to read and to sign. And that's how the agreement then is upheld. Also, I'd like to mention, it's very simple, people. The simple book of rent stabilization ordinances and one of rent stabilization regulations truly educate you, and fewer mistakes are made when one understands these rules and regulations, and they're all here. Thank you.
Mr. Commissioner, just to clarify, I don't believe that the unit that you live in is a rent-stabilized unit. It's an inclusionary housing unit, so it would not be governed by the rent stabilization ordinance. Is that correct? So it would not be pertinent to what we've discussed tonight.
It's not pertinent, but new buildings have that in their agreements. That's all I wanted to add to it.
Those are new non-rent stabilized buildings.
Exactly.
Correct. Thank you.
So we're already there. We're moving on from item 12, public comment, to 13, commissioner comments. Let's continue our commissioner comments.
I have no more. I apologize.
You're good to go.
I have a couple. Just if we can, when we have instances like this where we have a decision that while the decision is affecting one tenant only, where there may be a concern that it may be pertinent to other tenants in the building, if we can try and be cognizant of that fact and follow up with some educational materials to other tenants in the same buildings. Again, and maybe, I don't know if you want to discuss it at a later time, just to make sure that my understanding of charging for water in rent-stabilized units, unless you can sub-meter your property, I don't believe that that's correct. I'm also concerned about this particular MC Flores Property Management, or the LLC, and their principles, this document about waiving the tenant's right to relocation fees. Again, I don't think I've seen a rental building converted to condominium since late 80s, early 90s, but for any landlord or tenant to try and force that upon a tenant. So I kind of want to flag this LLC, their principles, and the management company, and any other instances that come forward we see where someone might be trying to Ellis someone out of their property without them receiving relocation fees. Even if a tenant tries to voluntarily waive that under the ordinance, my understanding is they are not allowed to waive those relocation. Am I not correct, or you're shaking your head? Okay, thank you.
There have been a couple of instances where we've had landlords come when there's an appeal, and it seems like they didn't realize some aspect of the law. And I know that we have these building block seminars and guidelines on our website. I'm wondering, do we also do like proactive mailings to landlords with bullet points of what you can and can't do to try to avoid more of these illegal lease provisions?
We do. We provide newsletters twice a year in addition to the seminars. We also have a lot of information on our website. We are in the process of updating and renewing that information, clarifying it, and also reorganizing it so it's a little easier to find right now on our website. It does tend to be a little, I'll admit, messy, but we are in the process. So towards the end of this year, I think that there will be a little bit of more reorganization, and it'll be a somewhat of a new website. When we're ready, I'll bring that back and we'll showcase that for the commission, probably in the beginning of the new year.
Great. And when we have the online registration fees, maybe it'll be even easier to be able to email all of the, not registration fees, re-registration forms. I'm wondering if it doesn't already happen, some of the specifics, like there was another case where a landlord tried to charge for a new tenant, and just if we can kind of make sure that it's real easy, real accessible of do's and don'ts, if it's not already happening, which it may be in the newsletters.
And I just want to add, obviously the city of West Hollywood is doing a lot for our residents and our landlords, but any business needs a lawyer. And you have to have a lawyer to advise you on proper business practices. And, this is, it's a private endeavor. It's a private, business. And we have to also respect them to have legal business practices.
Good point.
If this concludes commissioner comments, yes, we'll move on from item 13 to item 14, staff comments.
I do have one comment. I sent around to the commissioners earlier the City Council's resolution regarding what is now Prop 10. Just to refresh your memory, Proposition 10 is a ballot measure on the upcoming election to repeal the Costa-Hawkins Rental Act. Costa-Hawkins is a state law that put in place a number of limits on what cities could do to strengthen their rent control ordinance. One of those limits was to provide for vacancy decontrol, so that when a tenant moves out and a new tenant moves in, the landlord can set the initial rent at whatever rate the market will bear. Similarly, it prevents cities from updating their rent stabilization ordinances, and also has a number of other limitations that would be repealed if Prop 10 is passed. The City Council passed a resolution in support of Proposition 10. So in that landscape, I just wanted to remind the commissioners that, of course, you are free to campaign either for or against measures such as this, and you are also free as a body to vote either to support or oppose. So if you wanted to put this on a future agenda to talk about as a body, you are more than welcome to do that. But as individuals, be cognizant of using your platform as commissioners or city funds or resources to campaign. Thank you.
Do we have time to do that before the election? I don't think so. Do we have one more meeting?
You have an October 25th meeting.
Would we ask, one of us would have to ask for that to be agendized, and then there would have to be agreement. Is that correct? Yeah.
Sure, you could, if that's what you want to do, sure.
All right,
Someone want to make a
Lady
motion?
and
Okay, I will
gentlemen.
make a motion
all right.
that we agendize for the next meeting,
I'll second it.
whether or not to take a position and what the position shall be on Prop 10.
I second that.
I did, but you can do it.
Okay, so all those in favor? May we have? Oh, sorry.
I have a question
Sure.
before I pass my vote. So any discussion at the commission level, would we be discussing our personal thoughts on that proposition, or as a commission in the ordinance?
Right, so as a legislative body, you are allowed to take a position, and in the course of deciding whether or not to take a position, you would have to discuss your views on the matter, yeah.
So our personal views, let's say we can reflect in the Facebook or social media, it would be okay if we, as a private citizen, of course not as a commissioner, we can talk about it on our social media, right?
Yes,
and
of
it would be
course.
fine,
Sure, of course.
regardless of whatever action will be taken, let's say, the next meeting.
That's right.
Okay, Thank you.
I think we just want to avoid the Brown Act, so don't mention four of us, right? And ask us how we feel about it.
Yes, we have a motion and a second on the table.
Right.
May we have a vote? All in favor, please say aye.
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 All opposed? Okay, so that motion carries. Thank you for adding that to our agenda. I believe, is that the end of our staff comments for the evening?
I have a
Commissioner-
couple other comments. So we will put that on the agenda for the 25th. And I wanted to mention as well, in terms of information that we provide an information packet at new tenancy and to new landlords when they buy or purchase buildings in the city. The commission has asked us as a priority to look at other ways of outreach, and so certainly hearing the comments tonight and the thoughts, this has given me something to reflect on, and we'll certainly look at other ways of outreach and providing good messaging to the community so that folks are aware of what our rules are and our regulations and requirements. A general announcement from Yola Dore, who is your liaison from the Disabilities Advisory Board. She wanted the commission to know that next Thursday, October 18th, is the Disabilities Resource Fair, and this is happening at Plummer Park between 9 a.m. and noon. And at the fair, there'll be free flu shots, information and resources on numerous important issues, including technology, transportation, and medical. Also, she wanted to remind the commission again that they are hosting their annual disability awards, and that's next Wednesday, or the Wednesday following on October 24th. I believe that's here in City Council chambers between 6 and 8 p.m. And that concludes my comments.
Mr. Chair, I have a question for legal counsel. Allison, we're administrative adjudicators, and tonight you defined us as a legislative body, and I've never seen that in our definition, us being legislators. It hasn't been defined yet.
Well, under case law, it's a broad definition which includes councils and commissions. It just simply means that you're either appointed or volunteers. You're a legislative body as opposed to, you're a body that is subject to certain laws when it comes to campaigning. So.
But how can administrative adjudicators help to create a law and then judge on it?
So I don't think that when it says legislative body, it's a broader term than simply those who make law. So obviously, you can make recommendations to the council about certain changes to the ordinance. You're not doing it yourself, but that's not all that that's not all that definition encompasses.
But isn't that in the chain of making the law, creating the law? That's what I'm curious about.
So
Because
you're an in that capacity, you're an advisory body, but under the broader legal landscape when it comes to campaign finance and campaign laws, the judicial system and the laws consider you a legislative body.
If I may.
Is that,
It's kind of like, as a legal term, person can include corporations. They can it's a defined term that doesn't necessarily mean your common sense of what that term means, but they can define a term so it's not intuitive and might not match a dictionary definition.
I just would like to add that I think it's time we do create a new definition. I think I've brought it up many times at study sessions. I know that staff and some of you agree that this commission needs a new definition, and I think we should start creating it so there's more clarity on all these issues. Although it's something that I will bring up in the future to ask to be agendized. Thank you.
I can just tag in. I believe that both Yola Dore and Annie, and I'm blanking on her last name, are being honored by the county for their extraordinary work in the disability communities. Am I?
That's Annie Semenko.
Yes, thank you. By the County of Los Angeles, I think.
Yes, that is correct.
Thank you.
Terrific lady, if I might add.
Commissioners, any further comments or questions for staff? Okay, so with that, our next meeting is on October 25th. We will adjourn this meeting in the loving memory of Chrisanne Gregoire. Thank you.